Yes.
She is promoted.
And then if you could allow me to share my screen.
I've got some interesting questions I didn't share with you yet.
Oh man, you're gonna put me out on the
I am.
spot.
I'm going to throw you under the bus for sure. Wonderful.
All right, so Q&A session with your favorite title company, hosted by me. So some of these questions are questions that we have done in the past, revamped a little bit, and then some are questions that were given by the agents, that you guys are seeing real life, real time right now. So let's jump on into it. So the first question, and I don't know, we should have time at the end for open questions too. I don't think that we're gonna have all these questions that are gonna take the hour, but I think I always say that and we never even get through all the questions. So I guess we will see. First one says property was purchased by a single individual and the property is a homestead. We know the spouse will need to sign off at closing, but who do we list as the owner seller on the listing and the contract? The last deed shows the single individual in title. Does anybody, let me pull up the chat too. Oh,
What a great question. And these are real life real estate, right?
mm-hmm.
We come across these questions all the time and we need to know the answers.
So does anybody want to jump in the chat and make a guess on what this is, or if you know what it is? It's too early. Nobody's had their coffee yet.
Property was purchased by a single individual. They got
Lauren.
married after the fact,
Mm-hmm.
and the property is homesteaded. There's the question.
Lauren said both since they're married. Jennifer said who the property is titled in. It is who the property is titled in. So if it is Megan Duquette as a single woman and then I've gotten married, my husband will need to sign the deed acknowledging we're selling a primary residence. So it will be joined by my spouse on that deed, but the contract will only list my name. Your spouse does not need to sign all the closing documents. They're just acknowledging that the sale is taking place and the transfer is happening, which is the deed. All right, let's go to the next one.
Well, let's talk about that for a second, just because, I mean, my answer is going to be both needs to sign the contract, but I was wrong. So just you, in your example, Megan would sign the contract, but the husband would have to sign the deed, making sure that the transfer was legal because you're now married.
Correct. And if you have both signed the contract, we're not going to ask you to get a new contract because they both are going to sign the deed. But you only do need to have that one person in title signing that contract. That is the only one actually needed.
Okay, got it. Good title question.
All right, next one. Work was done on the home by a contractor. There has been no lien or NOC, notice of compliance, filed on the property, but the parties all agreed that the contractor would be paid from the proceeds. How can this contractor be paid at closing, and what documentation will title need to pay the contractor? So because the contractor has lien rights due to the direct contract with the owner, we would still require that contractor's final affidavit to be signed and released.
But there's no notice of commencement filed, so how do you even know about it?
If we are notified. So if the agent says, hey, there was work done on the roof, it's been completed, we're paying that roofer at closing. We're going to do a title update. And there's not going to be any, if there's not an NOC filed, we're still going to make sure we get an affidavit signed and released because that roofer could put an NOC on the property. So we want to make sure if they do put that lien on there, we're going to cancel it out regardless.
So let's go
Only
back
we
2
are aware.
steps. So generally speaking, when a contractor is hired, they
Mhm.
file a notice of commencement,
Correct, they should.
right? And that gives them lien rights on the property. If they don't do that, they technically don't have lien rights. But if you're aware of it as a title company, you have to make it be known.
Correct. And we
If
have
you're
to
not known, if the seller lied, which does sometimes happen. Right? You could miss it.
Yeah, absolutely. If the seller paid it in full and we had no idea and then NOC never got filed, there would be nothing for us to do. And if there was a lien filed after closing, then we can say, thank goodness that buyer purchase and owner's policy.
And you guys have something signed at closing called an affidavit of no liens.
The gap affidavit, correct?
Right. So it says, hey, seller swears that there's nothing outstanding.
Yeah.
So these games can go on, but we're going to protect ourselves as a title company to make sure we don't have to pay any claims because the seller's going to swear to the fact that there's no open claims.
Correct. Yeah.
Right. Not that we want to do that, but we want to protect ourselves as well.
Yeah. And this is also a good heads up for the listing agents. If you know that your listing is under contract and it is going to have work done, the notice or the roof is being done, which is the most common one I'm seeing right now, please give your title company time to be able to, one, wait for that notice of commencement to be recorded. And then for us to be able to get that contractor's final affidavit cleared. The seller cannot sign until that contractor's final affidavit is executed by the contractor, unless we're paying them at the time of funding. Then there's an exception at that point. But we cannot fund or close the transaction until that's received. So if we're having a hard time getting a hold of this contractor, or we found out 3 days before closing there was a re-roof, that could delay closing. So keep that in mind. Let title know, hey, we may be putting a roof on. At that point, we'll do title updates periodically just to check in on it. A lot of agents do that with us, and that's great because Victoria then will go in and see if we have anything, and we've caught it a couple weeks ahead of time. So we just want to be proactive with that.
Well, this is more relevant now than it has been before because
Yeah.
I mean, I've done 2 training classes in this lately. There's so much work being done with or without permits to bring the flood compliant properties back into habitability.
Yeah.
And so they're getting work done and they're not necessarily getting permits and they're not using licensed contractors. And all of a sudden we've got a non-permitted structure being done with no non-recorded anything. And it could be a problem for all of us.
Sarah said, a question just occurred to me. If there is no contract with the contractor, only a verbal agreement, but some work has been performed, can the contractor file a lien on the property?
Technically, no. They need to file a notice of commencement to protect their lien rights.
Which does put a lien on the property.
But if they don't file a notice of commencement, then they're a fool.
Yeah. Then they're not protected at all.
Yeah.
All right. Divorce couple. So per the divorce decree, and we're getting these a lot too now, so super important question. Per the divorce decree, proceeds are to be split 50-50, but the parties have agreed to allow one party to receive 100% of the funds. Can this be done? And if so, how? So A, yes, if agreed by both parties in person. B, no. C, yes, with the fully executed proceeds directive to disperse the funds to one party. And then D, none of the above. So let me see what you guys think before I just call it out. C, B.
I say C.
Getting a lot more C's for sure. All right. Yeah, the answer is C. Yes, they have that divorce decree, but if all parties do agree that one person is going to get all of them, we have what's called a net proceeds directive. If you have ever sat in a seller signing with us, then you know exactly what I'm talking about. And on that form, it tells you if they are receiving all proceeds, if it's going to be split, and then how it's going to be split. So if we're sending proceeds to another title company, they fill that out. If it's 2 parties on the contract and they're splitting it 50-50, they sign that. So they would sign that regardless with a divorce decree acknowledging the 50-50. So if they don't want it that way, they would just mark all proceeds to this party. It does need to be agreed upon and signed by both parties. I have had one a couple months ago where they did not agree, and closing did get delayed until the sellers agreed on how the proceeds would be split, because we cannot close with one party saying one thing and the other one saying something and just hold their funds. We have to have that form completed.
So Megan, why is A not correct?
Because it is a verbal agreement. We want to cover our butts, okay? If John Doe and Mary Doe agree verbally that John Doe is getting all of the proceeds, and we send all the proceeds to John Doe, Mary Doe gets mad at John and goes back to the divorce decree and says, I should have at least gotten 50 of these proceeds. We have nothing to say, no, you agreed to give him everything.
Yep.
Yes, verbal is as good
Verbal
as
agreements are not
written.
enforceable.
Yeah, absolutely. So we need a paper trail. We always need a paper trail. A lot of my agents hear me say that when we have little things for addendums, and I'm like, we do need an addendum for that. We need our paper trail. So if our file gets audited, or if the file, anything, we're covered. And not just we're covered, but in this case, John Doe would have been covered. So making sure all your bases are covered. All right. All right. If the property is owned by an LLC, how should the contract be written? So first, I want to remind the agents that if you have a seller or a buyer who is in the name of the LLC, always make sure that LLC is active. In Florida, you can check to see if if it's a Florida LLC, if they are active by going on Sunbiz. If you don't know what that is, you don't have that website, let me know. I can help you with that.
It's sunbiz.org. I go there all the time.
Me too. And you can search up by a registered agent. You can search up by the LLC name. Make sure that they're valid and active. If they're not, we cannot. There is a way for us to close with them not being active, but there is a lot of verbiage and a lot of things for the underwriter to add to be able to get them closed. So make sure that they're active. And then back to the question, because I got sidetracked. If the property is owned by an LLC, how should the contract be written? So Jennifer said LLC and seller, but the sole individual to sign. That is correct. And they will sign how their title is with that LLC. If they're manager, if they're CEO, if they're president, if they're managing member. Just as if you have a power of attorney, you're saying this person as power of attorney, you're doing that with the LLC, making their title known.
Well, let's discuss that just a little bit. So an LLC is basically a shelter that protects the individual. So I own quite a few LLCs. And if I signed as Craig Beggins, then I'm signing as myself. But I signed as Craig Beggins / manager of the LLC. That shields me from my personal belongings, right? So whenever I sign anything, it's Craig Beggins manager. So I'm not signing as Craig Beggins personally. I'm signing as Craig Beggins manager of the LLC, which is the titled seller on the contract.
Yes.
So we don't want our customers signing as themselves. They want to designate their title. And generally speaking, as an LLC, you can be a manager. As a sub S corporation, you might be president or something else. So that's just one of the things. LLC is a limited liability company, correct?
Yeah. And then just to also throw in a question that came to my mind, if the property is owned by a trust, how should the contract be written? So
trustee.
Yes, and your trustee is always going to be the one to sign. A power of attorney can never be used on a trust in the state of Florida, which a lot of the agents already do know that. So we don't see that coming up too much. But when you sign off on the deed on a trust, you're going to sign off as an individual and as trustee. You're signing over your personal rights and your trust rights. So if you've ever sat in a closing with a seller who's a trust, they have to sign 2 times per person. That is why they're signing as individual and as trustee. Right.
I didn't know that. Actually, I do know that because I've had to sign as individual and trustee for different things.
Now you're thinking about it and it's coming back. All right. Next one.
Like everybody else, we just sign where they tell us to.
Yeah. Seller has a survey and the only change change made to the property since they purchased the survey was that a wood fence was added. Can this survey be used at closing, or will a new one need to be ordered? No, the
Ooh.
survey may not be used. Yeah, and I answered that too quick, but Jennifer, you got in there and you said new survey. May not be used. If they
I was
want,
going to say that it could be used, but there would be an exception to the policy. Exclude.
correct. But if there is a loan, the lender is not going to want to take exception to that. It is very rare chance that they want to take exception. So a new survey would need to be ordered to issue that lender a clear Florida Form 9 endorsement. If it is cash, then by all means, yes, you can absolutely use it. But if there is a loan involved, the lender is not going to want to take exception to it, and we will have to order a new survey.
Yeah, but as a rule, this is my thing. If the lender requires it, you should require it.
Mm-hmm. Yeah,
right.
absolutely.
I mean, the lender is doing this for a purpose. They want to protect their asset, their collateral.
Yeah.
Right.
And
So there's a
Tracy,
cloud potentially on the title. So if the lender requires it, you should require it. My
Absolutely.
general rule.
And Tracy asked if the older survey can be updated. If it was something, if it was a recent survey and it needed to be recertified, that could be up for discussion to where we could just update that survey and recertify it to our clients and to us. But because a whole fence was added to that survey, they would have to go back out to the fields and do a whole new survey. It can't just be marked on the survey and added on. Fences
So why is that? Because the fence people are fence people. I don't mean to call them a name, but they could put the fence 2 feet over on the neighbor's property.
Correct.
Or they put the fence 2 feet over on your property.
Right.
And then you not technically, but you'd be giving up 2 feet of your property.
Right.
So the surveyors
Usually,
mark where the fence should be.
right. Usually in the past, this is Michelle speaking, sorry.
Hi, Michelle.
Hey, so we used to say a fence technically isn't a permanent structure because you can move it. However, there are so many discrepancies and so many issues when you don't have a survey, or if a new fence is put in and then there's differing opinions on whose property line it is on. That's why you need to get a survey, and also prevents the buyers from thinking they're getting more property than what, I mean, what if they put the fence in the neighbor's side and now they're getting less property than what they thought because it's not technically on their property? Does that make sense? Like
yeah.
So that's why, especially with a fence, even though it's technically not permanent, we're calling for it because there's been too many issues after closing.
Well, Angelique and I bought a property in Brooksville and the fence was 25 feet on our property from the neighbor's fence.
Right. So they can be
25
getting
feet.
less
That was a lot
property
of
than
property.
they think. Yeah, or more property than what they think. So it's definitely a good idea to do that. There's been so many disputes over property lines because of fences. Because you just assume when you see the fence there that that's yours. Well, it may not be.
Right.
So that's why it's definitely important to do that.
That's why I say never, ever, ever buy a piece of property without a survey.
Correct. I agree.
Even if it's cash and it's not required by the survey.
Yep.
All right, next one. Seller has a name change. They're married, they got divorced. How should we list the name on the contract? So example, the last deed and county site shows Mary Smith, but per her driver's license, she is now Mary Brown. So how should we list her name on the contract? Should we use her current legal name, or should we use the name that is on the deed and the county site? Does it matter?
Oh. Can you do an AKA?
It wouldn't be an AKA, it would be a FKA, a formerly known as.
Okay.
So you can use, you can use either her name on the deed or her legal name. She will sign as her legal name. That is who she is now. So she will show on the contract as Mary Brown. And then when the commitment comes back, we'll see Mary Smith. When we do our intro call, that's obviously going to be a conversation. Hey, have you had a marriage, divorce, whatnot? yes, I have been married. Okay, perfect. So we're going to do Mary Brown, formerly known as Mary Smith, on that deed to show that she is the same people. When she signs, she is only signing her legal name of Mary Brown.
Wow, these are good questions, Megan.
Thank you.
I mean, this is real life real estate right here.
It's different. And Kelly, you don't need documents to show why the name is different. We're not going to ask for her marriage certificate. We're not going to ask for that divorce decree. As long as she confirms that she is that person, she's signing that deed with that formerly known as on there. So she is acknowledging that at the time of closing. So we wouldn't need supporting documentation for that. All right, I don't see.
Jimmy Buffett has a song called Useless But Important Information. Right?
Mm-hmm.
This is stuff you don't think you need to know, but it just makes you an expert when you do know it.
Yep. Absolutely. All right, next one. Is a power of attorney good for forever? Can it be used for a party after they pass away?
Ooh.
So A, yes, regardless of the type. B, yes, if it's a durable power of attorney, but it is only good from the date it is executed until either resigned by the principal or at the death of the principal. Or C, POAs are only good for 30 days. Tons of B's coming in.
I've got a D. I thought the power of attorney died with the party. But I could be wrong.
So it is B. So if it is a durable power of attorney, it is good from the date is executed until they either resign or the date of their death. No power of attorney survives the death of the principal. There are other limited power of attorneys that can be used that are good for a limited time. So like if you have ever gotten a power of attorney from us for the specific property transaction, there is an expiration date on that power of attorney. It is also only valid for that legal description, but there is an expiration date. So there are some cases where they do expire within a certain amount of time, but a durable power of attorney is only good until they die or they resign.
Okay, so I was right. There's a D.
Yes.
It dies upon the death. Come here, Wonder Puppy. Come here.
All right. Let's keep going on. All right, next one, which we're getting these a lot too. What are some key items that the agents can look for on a power of attorney to know if it will be acceptable? So we've been getting a lot of power of attorneys that have been already prepared and signed on and sent over to us. The biggest things that are missing that they're not getting approved and need to be corrected is the witnesses' names are not printed under their signature line. It is an easy item to fix. Especially like we have some that were notarized with an attorney's office. They still worked there. We brought it back. They signed it or they wrote their name. They're good. But these are some key things if you do get a power of attorney from your seller to look at, just make sure that they have, and then we'll review it, make sure it has that verbiage to be used for closing. But the witnesses' signatures need to be on there, 2 of them, with their printed names below that. If there are no witnesses, the power of attorney will not be approved unless it's a military power of attorney. There are exceptions for military-based power of attorneys. The second one is the notary block is to be completed in full with the stamp. And it cannot be an oath. It has to be a notary acknowledgement. We just had one recently that was not approved for closing because instead of the word acknowledgement in the notary block, it said an oath. And you cannot use that to record for a deed, and I learned that from our underwriter. I did not know that. So I learned that a couple of weeks ago when we have a power of attorney that was done under oath.
There's also something called an apostille. You know what that is?
I do not.
When you're in a foreign country,
Correct.
you can't just notarize something.
Right.
Because
Yeah,
it's not
they call them different things depending on the country that they're done in. Yeah.
So I've got dealings with a guy in Spain, and he has to actually travel to the consulate,
Right.
to get an apostille signed to make
Mhm.
his notary legal.
Correct.
So when you're dealing overseas, it's more of a challenge.
Yeah.
Mhm.
Next question, property appraiser shows 4 people in title, but they are shown, excuse me, but they are shown in percentages. Example, Mickey Mouse Senior, 50%, Minnie Mouse, 50%, and then Mickey Mouse Junior, 0%, and Mickey Mouse the Third, 0%. Lady Bird, aka Life Estate Deed. Who do we list as the sellers on the listing contract? Do they all 4 need to sign?
Ooh,
Jennifer is saying yes, they all.
I would say everyone. That would be my guess. Just to be safe. But the Ladybird Trust says it's a life estate. So whoever's living gets it. I'd still sign everybody because I'm not going to show this title unless I know everybody's giving up their rights.
Mhm. So Sarah is correct. All
Wow.
4 parties do not need to sign because it is a Ladybird deed. The other 2 parties, so Mickey Mouse Jr. and Mickey Mouse the Third, do not have interest in that property unless Mickey Mouse Senior and Minnie Mouse pass away. Once they both pass away, then they have that interest and they will need to sign. But until then, they have no interest, they have no rights to that property. They have no say-so. But
Ooh, I
do
stand
not,
corrected.
yeah, do not rely on the county's property appraiser's office. Always go off of your deed. So go back and look at that deed, see what the deed says. Is it a life estate deed? Is it a Ladybird deed? If it is, then yes, you have your confirmation, but don't just go off of what they're showing as the owner, because they can make mistakes just like everybody else. So, right.
Except for me.
Yeah, except for Craig.
No, I just made a mistake, so I admit it. It'd be safer to have everybody sign, but you don't need to.
Correct.
You
Yeah.
don't
And then,
need to. Yeah, that's a Ladybird deed is also called an enhanced life estate, where it will list who's entitled, and then, like in this case, the junior Minnie Mouse and Mickey Mouse, or Mickey Mouse Jr. and the Third would be listed as remaindermen.
mhm.
So if you have just a regular life estate deed, then all parties would need to sign because one person reserves a life estate interest. However, they cannot transfer title without the additional person knowing. They're just reserving a life estate interest in the property, but then whoever else is listed on there with them would have to acknowledge. It's only on an enhanced life estate where they are listed as remaindermen that, or the Ladybird deed, that only the 2 are entitled while they're alive. Does that make sense?
Yes.
So Sarah asks, that
Yeah.
does not pass through probate. So when you have a deed like this, you don't have to go through probate. For example, I have personally used a Ladybird deed. It was a life estate deed. My grandmother left me and my sister her property, and she had a deed signed before she passed away, acknowledging that when she passes away, it goes to me and my sister 100%. We did not have to go through probate. As soon as she passed away and her death certificate was recorded in public records, the property appraiser website updated the ownership to my sister and myself. So probate's not needed. And it made, from having that personal experience, I will always recommend these type of deeds for the, elderly, or if somebody is sick, because it made our process so much smoother. And when I have a closing and I see somebody in probate and they're going through all of this, they don't even have time to grieve. They can't even take that time to themselves to grieve for whoever they have lost. Me and my sister, it was just seamless. I mean, we were able to get the house up, list it, get it done, and be able to grieve the loss that we had. So I always recommend these. If you ever need one prepared, we do have our in-house attorney. So please, if you don't have his information, let me know.
That's Danny, just so everybody knows.
Yes, yeah.
Danny Escanos.
Can a quitclaim deed be signed, witnessed, and notarized at a U.S. embassy in Spain by a U.S. citizen?
That's where the apostille comes in.
Yeah. We have people who are out of the country and they need to sign their closing documents, and they're U.S. citizens. They're just not in the country, so they have to make an appointment for the U.S. embassy, or they can do remote online notary session. We do have that option now.
Which is super cool because when you deal with a smaller title company, they just don't have assets, access to those assets to make it happen.
Absolutely. All right. So what are the benefits of a seller providing their prior policy? Why does the title company request this?
I'm gonna be quiet.
Yeah, the reissue rate credit, that is one of the benefits. Mhm. There is another benefit other than just the discount. So the discount, yes, it can be applied if that policy is received and they purchase it within less than 3 years, if it's a purchase. A resale. But if there are exceptions on our current commitment that have actually been insured over in the prior policy, we may be able to remove those exceptions from our policy by referencing that prior policy. I have had a requirement on a commitment come up and asked the seller for their prior owner's policy because it was for their the prior owner before them. And it was not added as an exception with them, and we were able to remove that requirement by using their prior policy. So it is important to have. Not every time are you going to be able to utilize it, but it's nice to have in your back pocket if you do need it. Yeah, Rachel, it shows the prior trail too, absolutely. All right, if
Yeah,
a
'cause you're only
contract,
insuring the difference between the previous policy and the new policy. Because the previous title company was insuring the past. You're
Mhm.
just updating from the previous sale to the current sale.
Correct. Yeah. A lot of times what I see is if it's a quick close between when they purchased and they're selling, the mortgage from that prior owner has not yet been satisfied. So it's coming up on our commitment. So we reach out to either that prior title company or the seller, get their prior owner's policy and show that it was not added to the exceptions. Sometimes I'll even ask the title company for their settlement statement to show, yes, they collected for this payoff. And that way we can strike that requirement knowing, okay, it's been paid, they just haven't recorded the satisfaction yet.
Now, this whole conversation is making me think about how important it is that we recognize the work that goes on behind the scenes, right? Because we're just real estate people out there, showing buyers and sellers and doing what we do. But all this work that goes on behind the scenes is important,
Mhm.
right? And
Yeah,
you guys do all that. So thank you for what you do.
absolutely, of course. It is a lot, but we have, and like most of you do know, we have tons of resources and departments internally to help us with these types of things. All right, so next question. If a contract is originally written with only one person purchasing the property because they are the only ones getting the loan, the wife, girlfriend, whatever is left off of the contract, can a second person, the wife or girlfriend, be added to the deed? If so, what does the title company need? And what additional documents will the second person need to sign? So this is a very involved question.
It really is.
Yeah, and generally speaking, to add a person to the deed at closing, we do require an addendum to the contract. Acknowledging we're adding that person to title. We have to also verify the lender is going to allow that person to go on title. If they do approve that, they also are going to not only acknowledge and sign all of our title documents, they are acknowledging that mortgage as a non-borrowing spouse, a non-borrowing party, but they are going to have to acknowledge a lien is being placed on the property. If they do not, the lender does not have a valid lien. If they ever try to foreclose, they are going to have an issue because the person who does not sign can say, I had no idea there was a lien on this property. I'm staying. They do not have to sign the promissory note because they are not responsible for paying back that money. They are just acknowledging that they are living in a home with a mortgage on it. The only person who has to sign that promissory note is the person who is on that loan application and on the actual loan. But our deed has to match the mortgage. So if we have John Doe and Mary Doe as husband and wife on title, but only John Doe is on the loan, John Doe as a married man joined by his non-borrowing spouse will be acknowledged on that mortgage. Everything else will only be signed by John with that lender. So that's including the note.
Isn't it
Mary,
nice that they do all this stuff for us?
yeah.
That you guys as
You don't
title?
have to worry about it. When the
Okay.
lender forecloses, they name the spouse. They will use the lien that is recorded in public records, which is the mortgage. And if they purchased that house when they were married and it was their primary residence, then yes, it will, they're going to foreclose against the property, which is the people who are listed on that mortgage. That's not saying that that spouse is going to get that credit hit because they're not acknowledging they're paying back that money. That would be just that person on the loan who signed that note. But this is saying that spouse can't go squat in the house because they had no idea there was no lien on the property. Even if the spouse was not. Well, if it is a primary residence, the spouse should be acknowledging the mortgage. In the state of Florida, we are a homestead state. So if they are married at the time of signing and primary residence, the spouse should be acknowledging that mortgage. Perfect. All right. Next one.
Man, you got a lot of questions.
We actually are only down to 2 more. So we are going to finish a bit early today if nobody has any additional ones at the end, but.
No, it's good.
All right. As a real estate agent, when I am reviewing the CD with my clients, what is the best way to explain the endorsement charges? I don't know if a lot of agents do. A lot of agents know what the endorsements are on our closing disclosure and our settlement statement.
Nope.
I don't see any coming through either. All right. So endorsements are additions to the policy coverage, and they are intended to remove exceptions to the coverage. Title insurance starts out insuring everything on title, but every policy includes a fairly long list of possible claims from the coverage. For example, problems that appear on a survey or would appear on a survey if one were obtained will not be covered by the title policy due to the survey exception. However, if you obtain a new survey, pay for that survey endorsement, and there are no encroachments or other problems showing on the survey, then something is later determined to have a problem that we missed on the survey, then the policy coverage can help fix for the problem because you had that survey endorsement. Without the endorsement, the buyer is on their own to fix any problem. It's like buying flood insurance. If you don't buy that extra coverage and you get flooded, that claim is excluded from your regular hazard insurance and you get no assistance from your insurance company. Does that make sense to everybody? So there are 3 generic endorsements that every lender requires in the state of Florida. The Florida Form 9 endorsement, which I'm sure all the agents have heard us talk about. That is your survey. If it is not a condo, we are ordering a survey. The lender is going to want that endorsement on their policy. The next one is the environmental, which is 8. And then if it is a homeowners association, there is an endorsement for the PUD. There's also a separate one for condos. If you have a construction loan, they usually require at least 5 endorsements. So it can get pretty lengthy. But if you ever want to understand what they are, just reach out to us. India, myself, we can always go over what each endorsement is and what they cover for your client. All
The
right.
dog was eating her bed. Wonder Puppy.
Seller is listed as an individual, but they want their proceeds made out to an LLC, or the other way around. Can this be done? Or the property is held in a trust. Can the funds be made out to the individual? So this is actually a senior office policy decision. Legally, it can usually be done with the proper signed directives, but it is up to our management whether to approve this or not. If it is in a trust, they want to review that trust and any addendums along with it to see who that beneficiary is. If there is more than one beneficiary and only one wants the funds, no, it cannot be released to that one person. Same with an LLC. We need to see all the LLC documentation, and that goes up to our division and regional managers to be able to review and advise if it can be done. We always say at the beginning of the closing, if it's in an LLC or a trust, to ensure you have a bank account set up with that LLC or trust, because we don't want to come to closing and you provide an individual check for the trust account, and now we have to ask you for all these documents and get that approval. It can be a lengthy process. They have to look over all of these documents. So it is not impossible, but there is a lot that goes into it. And there is a chance after providing all of these documentation that it will not get approved. And if you don't have a bank account in the trust or the LLC, a check will be provided for you to open that account. And this is something that we do to protect your funds. This is strictly to protect your funds, just like when we have the agents who want us to wire your commission. I have you guys fill out the disbursement authorization form. That is to protect your funds to ensure they go to the correct place. That is also just a company policy that we have put in place as an extra protocol on our side. All right. Does anybody have any other questions?
These are really good thought-provoking questions that we don't think about,
Mm-hmm.
but now we're consciously aware of them. So if something were to pop up, we could go, oh, check with Megan.
Yes, always
That's the
check.
goal, right?
And anything you guys hesitate on or have questions on, just reach out to myself or India. If we don't know, we're going to ask either management or the underwriter, and we will get an answer for you. Because you're always learning in title. So there are things that we are not going to know the answers to, but that's why we have the resources we do. Jennifer, I'm not sure certified for sellers to receive a wire. I'm not quite sure what you're asking. Michael, yes, we did see your Spain question. We did acknowledge and say, yes, they can.
Kelly says, we stay online for a minute after I have a question. That's good.
Yeah, absolutely.
So Kelly, I'll turn the mic on so you can ask us all.
Yeah, we have time
Need
now.
access to the Alfire River through a non-exclusive easement across the east 23 feet of Ashman Road from River Cove Drive south 200 feet to the, oh my gosh. You must have copied and pasted this, I hope. See attached appraisal with warranty deed. Yeah, if it's on the deed, you're covered. I mean, that's ingress and egress.
Mhm.
So if there's an easement that gives them access to the river from a subdivision plat, as long as it's on the deed, then that's it. Because when the survey is done, the survey is going to say
That
here,
is-
here, 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 and here, with an easement going to here.
Let's see. If you purchased a home in your name and it's paid off, then marry, is there any reason for a ladybird deed? So a ladybird deed is for if you pass away,
Mhm.
to be able to put all the interest into that party that you're giving it to.
Right.
If your spouse isn't on the deed, and this may be a question for Michelle to jump in, and if your spouse isn't on the deed, and you pass away, does that automatically go to your spouse, or do they have to go through probate?
No, if spouse is not entitled, it will call for probate. So if they even if they own it free and clear and they get married, it would be in their best interest to add spouse to title. They can do a quitclaim deed, or just a warranty deed, and she would deed it from herself to herself and her spouse as husband and wife. That way, if she passes, it automatically passes to her husband or vice versa.
So Megan, if
would-
your mom were single,
Right.
and she had a ladybird deed, if she dies, it goes to you and your sister,
Correct.
right?
Ladybird deeds are more for estate planning purposes. If you're wanting to have something go to a loved one, not your spouse. In that instance, if she's married, I would just recommend putting them in title as husband and wife.
Right.
Now,
So my
if they had
second part of my
kids
question
that
was
they
then, like,
wanted
if your
it to
mom
go
then
to-
gets married after she does the
Right.
ladybird deed, then she
Right.
gets married, then she should add her husband to the deed.
If she wants to, but
If she wants
may
to.
not want to, because I mean, you may have, if there's siblings involved, they may not want the husband to be on there. They may want, you know what I mean? So
Oh,
that,
do the siblings have to sign?
well, if you get married and you want to add your husband on there, that's no problem. But if it's in your mother's name and your mother wants you as the remainderman and their siblings, yeah, I would ask the siblings about that, because
Mhm.
They may not want the husband on there. They may just want, I mean, they could all be married and not want the spouses on there. They may want it just to go to the children.
Yeah.
So those are questions you would have to really ask, but a ladybird deed, I would kind of, in your mind, think of it as for estate planning purposes.
Mhm.
In an instance where they're married, I would just add the spouse to title and make sure they're joined as husband and wife.
And Lauren had a good point too. She said, I just did joint tenancy with right to survivorship for the condo I bought for my mom. And
Yep.
that's
That is
perfect.
perfect. That
Mhm.
puts you entitled no different than husband and wife would. It's tenants by the entirety. You guys are entitled so that if one person passes, it automatically goes to the other. So that's good that you did that.
Yes.
Yep.
All right, Jennifer. I'm not sure what app you're referring to fill out to claim their identity. If you want to elaborate on that more, or we can touch base after, totally up to you. And then if a contract fell through and the seller and buyer are in an escrow dispute, can the property be relisted and sold closed with an open escrow dispute? Yes, they can. Yeah.
That's a big question because a lot of buyers think, oh, well, I'm just not going to release escrow and tie the seller up so they can't sell the property. Yeah, they can.
Yeah.
Yeah.
We have one that is actually still in escrow dispute, and I've had it for maybe 2.5 years now, and it's still in escrow dispute because they're going to court for it. But we closed the property within that same year. So it
That's
is
a legal term because now the damages have been sustained. They know what the damages are.
Mhm.
And they probably weren't that much. So they're probably going to get the escrow back.
I have argued this with many people, and I agree with you. Yeah. Yeah. All right. Well, does anybody have any other questions? Craig, do you have any questions?
No, I think we covered a lot today.
Perfect.
I just think it's important to note that, it's a partnership between real estate and title and mortgage, that it takes a village to raise a child. And basically that's what we're doing. We're selling properties and we're selling lots of them, but it's not just our efforts, it's your efforts and the mortgage company's efforts at the same time that make it
Yeah.
all come together. Kelly, you want to unmute yourself?
I think I'm unmuted. Am I unmuted now?
Yes, you are.
Yeah.
Okay. So there's a section, this is personal, so people, not personal to me, but and it's specific to a neighborhood. So
Okay.
there's a bunch of houses that have that clause on their deed, and they are trying to sell their house saying that they have access to the river. Well, the person who owns that piece of land has blocked off that access and actually planted a tree and hasn't maintained the boat launch or the wall. So he says that his attorney says he doesn't have to provide them access, but if it's on their deed, what makes it where he does have to provide access, or does he?
That's a Michelle question.
Well, if it's on their deed, I mean, they're granted, that's a perpetual easement that goes with the property. If they were deeded it, then they do have access to it, no different than he does. They
Okay,
all
so he-
have, if it's a common road, which is what it sounds like, it's a common thing where they're all accessing the water from that.
Yeah, so it's been going, it's decades now that he's blocked that off. So he's just, he paid somebody some amount of money. So he thinks he doesn't have to give anybody access to that. So does everybody in the community have to come together to make him take that down, or?
They're gonna have to, I would get a real estate attorney for that because they do have access via their deed. They were granted that and they were conveyed with their property. When they got the property, they were conveyed access. So
Who's responsible for paying to maintain the access? Because it's not free to maintain seawalls and boat launches and stuff like that.
that
There's an
would be,
expense to
you'd
that.
have to look in the bylaws of the association to see who's responsible to take care of the seawall. It doesn't sound like it's a private road agreement. It sounds
It's
like
not a private road, but I
Right.
think that the homeowners association that started in the beginning has been dissolved, but they still have that on their deeds, but nobody ever maintained it. So he bought it.
Gotcha.
And
Yeah,
so he
but-
says
You can
since
get
he
title
bought it,
insurance.
he doesn't have to give them access.
I
I
don't
don't-
think that's right. I think he needs to get a real estate attorney, or they need to get a real estate attorney
Yeah.
because that is not right.
I was just curious your perspective from the title company, because it says on the listings that way. Thank you for at least hearing me out.
Yeah, no, I mean, I honestly, that sounds like something that an attorney is going to need to answer because they do have rights because they were conveyed those rights when they purchased the property. Now, if
Okay.
he's blocking it, then that's going to be a civil matter between the homeowners and him to get, and they are gonna have to enforce that to get him to move the tree or whatever is blocking the access.
Okay, thank you.
Yes, ma'am.
That is a great question, Kelly, too.
That
That
is a
really
good
is.
question.
And that just gives you an example of, and I say this a lot lately. This is why real estate agents provide value,
Yep.
right? It's not because of what we know or what we do. It's because who we know and what we do,
Yep.
right? And
100%.
knowing where to go. So it's my old story about, I paid you $500 and all you did was turn that screw. Yeah, no, you paid me $500 to learn which screw to turn,
Mhm.
right? And that's the difference. So having the resources available at our fingertips makes all the difference. So having the Danny Escanos at our
Yep.
fingertips and a
And
Megan,
Danny,
a Michelle,
Kelly,
and
if you have Danny's information, you can definitely reach out to him and he can talk to you to see what the options are on that if you have a specific
yeah, that's what I would do.
scenario. He'd be a really good resource for you without your clients, and he can point you in the right direction or tell you exactly how to handle that.
Yeah,
Well,
I
let's
want
be
to go
clear.
after the expired listings in that neighborhood, but this topic keeps coming up. And so I just wanted somebody to guide me a little bit.
Yeah, I would definitely reach out to Megan and get Danny's contact info and he can help you.
Thank you.
I'll send
Yeah,
it
but
to
understand
Kelly.
when you talk to Danny doesn't represent us.
Right.
Danny's our attorney. He doesn't represent our clients.
Okay.
So they're gonna have to get their own counsel. He'll give you advice on what
Right.
to tell your customer, but they're gonna have to get their own counsel,
Correct.
right? Just to
But he
be,
could at least give you some more legal information than what I have knowledge of, because
Right.
there's a lot that goes into that, but he can definitely help you and point you in the right direction.
Mhm.
and he's super nice to talk to.
Yeah.
Yeah,
Cool. Well, thank you, ladies. I think it was a very informative class.
you are very
Thank
welcome.
you.
Yeah, you guys have a wonderful day. And if you need anything, as always, please reach out to myself or India. And we are here to help. Hope you
Okay.
guys have a great week. We'll see you on Tuesday.
Thanks,
Thank
everybody.
you.
Thank you, Michelle.
All righty, no problem. Bye.
Bye all.
Bye.